In California Franchise Tax Board versus Hyatt, the core issue is whether the Supreme Court should overrule a 40-year-old precedent called Nevada versus Hall that had decided that states do not have sovereign immunity in the courts of their sister states. It's one of these cases that has been up and back to the Supreme Court a lot of different times. The whole issue started in the early 90s. Gilbert Hyatt is an inventor, and he actually lived in California, and he made a lot of money off of technology patents. He then moved to Nevada. The California Franchise Tax Board is the agency in California that is responsible for assessing personal income taxes. And in 1993, they audited Mr. Hyatt and decided that he had actually moved out of the state of California about 6 months after he claimed he had, which resulted in a certain amount of unpaid income taxes. Mr. Hyatt alleges that the California Franchise Tax Board, in its auditing process, committed a number of intentional and negligent torts, including looking through his windows, rummaging through his garbage, contacting family members and co-workers. And because of that, he not only sought an administrative appeal of the tax determination, but sued the California Franchise Tax Board, which is an agency of the state of California, in Nevada State Court. The only issue left in the case is whether the 1979 case Nevada versus Hall should be overruled. In Nevada versus Hall, the majority there decided that there was no interstate sovereign immunity because it is not found in the text of the Constitution or the text of the 11th Amendment. In subsequent cases, the court has said that sovereign immunity is something that states had before ratification, and that the question really is whether the Constitution, in its enactment, changed the scope of sovereign immunity to which states were entitled. The actual concept of interstate sovereign immunity is not found in the text of either the 11th Amendment or Article 3, and that's really not in dispute in this case. Really, the question here is, what are the baseline principles of sovereign immunity that existed before ratification, and did the Constitution change that? The best argument for the California Franchise Tax Board is that Nevada versus Hall got the analysis for how to determine whether a state has sovereign immunity exactly backwards. The question that the court asked in Nevada versus Hall was, is interstate sovereign immunity something that is identified in the text of the Constitution or in the text of the 11th Amendment? But in other cases, the question is not whether it's identified in the text, but whether states had that sovereign immunity before ratification, and did the Constitution abrogate it? Did it get rid of that aspect of sovereign immunity? There are actually two good arguments for Hyatt. The first is that Nevada versus Hall was rightly decided because when you look at the history and the structure of the Constitution, states were more equivalent to independent nations. And as explained in a very old Supreme Court case, the Schooner Exchange, nations did not have sovereign immunity in the courts of other nations unless the host nation chose to extend that sovereign immunity. The second argument for Mr. Hyatt is, even if a majority of the court disagrees with him about whether Nevada versus Hall was rightly decided, the court is going to need to determine whether the factors that they usually consider for overturning a precedent of the court are satisfied here. On the one hand, what you have is a state agency saying that it should not be subject to the courts of another state, that it has, as a sovereign entity, dignity and independence, and shouldn't be hailed into those courts to be subject to judgment by a different state. On the other hand, the host state has its own sovereign interests in protecting its own citizens and in being able to have decided in its own courts the lawfulness of activity that has occurred within its borders.